Welcome, everyone. This is the second last episode or second last session of Opportunities Australia. And this is about the legal requirements for you to open up your business. So we have got, a few lawyers out here, and I'm pretty sure Simon and George and one other colleague of Simon from Kennel Guys would come around, Warwick, and be able to help you out as much as you could. And Sydney is here, and Michelle and some other people from Opportunities Australia will help you out in this session as well. So, yeah, after you, who are we heading? Is Simon going to start? Yeah, okay, go ahead, Simon. Thank you.
Hi, everyone. I'm Simon Leslie. I'm a lawyer. I mainly work advising startups who are starting their business all the way through as they grow, and also investors into startups on sort of the arrangements around their companies. I'm just going to give a fairly short presentation, fairly high level, about companies and company law and things that I think it's really important to understand when you're starting out a business and you're going to be setting up a company. And it's a little bit high level, a little bit academic almost in some ways, but it's things that if you don't understand, you're going to get tripped up down the line. And it's better to understand it from the outset. After I've finished speaking, one of my colleagues, Warwick, who's going to be joining us shortly, hopefully, will talk a little bit about intellectual property and about the different types of intellectual property that exist under Australian law and internationally. And then George, who I think a number of you may know, will be giving some information about commercialization of intellectual property. I've got some slides that I'm hopefully going to put up on the screen now, and let me know if it doesn't work.
It is working.
Okay. So this is what I'm just going to run through today. We'll talk about shareholders, directors in the company, the different roles of different people. I'm going to talk to you a little bit about separate legal personality, limited liability, what that means, and some common group structures. Because often companies don't act as a single company, they act as a group of companies. And it's worth thinking about that early on, although I'll explain why you probably don't need to be thinking about it right from the outset. I'm going to be talking to you about directors' duties. So this is the role of a director and things they need to be mindful of as they're acting in relation to a business. I'm also going to be talking a little bit about shareholders' agreements. Where you have multiple shareholders in a company, typically there will be a shareholders' agreement put in place which governs the relationship between the shareholders. And it's something that's important to think about, and I'll sort of give some examples of why. So the first thing here, the first slide here that I really want you to be thinking about is the difference between shareholders, directors, and the company. And on this slide, you can see that there's a company in the middle. The company has employees sitting below the employee. They're the people that are actually doing the work. They're employed by the company. They have employment agreements. They have rights under the Fair Work Act, and they get paid by the company. But they don't necessarily own the business. They don't necessarily have control over the business. They're the people that are just sort of operating the business operationally and making things happen. In this diagram, sort of above the company, you can see the shareholders. Here, there are two of them, two individuals own the company. Shareholders can be companies, they can be individuals, they can be funds. They can own companies in different proportions. So one person could own 90%, one person could own 10%. They can also have different types of shares. So typically, companies have what are known as ordinary shares. And ordinary shares just are basic shares and effectively represent an interest in the company. And if there are 100 shares in the company, each share represents 1% ownership rights. But there are different types of shares that exist. Some shares can be more valuable than others. And often investors into companies will want to have preferential shares with preferential rights, that are sometimes referred to as preference shares. And then on the left of the diagram, there's the directors of the company. And the directors are a slightly odd role. They don't necessarily have any ownership in the business. They don't necessarily have any employment contract with the business. They don't necessarily do anything on a day-to-day basis. But their role is one of sort of oversight and control of the business. And their role is to act for the shareholders in connection with the business. So their role is to sort of maximize returns to the shareholders, whether that's in terms of freeing up money to pay dividends to the shareholders or increasing the value of the company so that shareholders can participate in that growth of the business. And I sort of started with this because I think it is really important to understand those different roles and to understand that one person could be in literally every one of those roles. You could have someone who is a shareholder. They might even be the only shareholder in the company. They own the company. They are also employed by the company. They get paid a salary by the company and they work for the company. And they might also be a director of the company, the person that has that control function. But when they have those different roles, they act in a different capacity in each of those different roles. And it's often important to remember that, particularly when it comes to directors, because as we'll come on to later on, they have directors' duties. They have ways they have to act in connection with the company and potential liabilities if they don't act appropriately. Now, a lot of companies, when they start out, only have a single shareholder, often the person that founds the company, the founder. And often that person will also be the only director. And for a time, they may also be the only employee if they have an employment contract. But later on, as the company grows, you'll often have more shareholders come in as people invest in the company, or if you have a co-founder who works with you. And you might also have more directors. And so the differing roles of these different parties, it really becomes more important later on than early on in the company's life. But if you start thinking about it early, it'll help you avoid legal issues down the line. So just on the next slide, I'll just talk about two legal concepts. And the first one is separate legal personality. And in England, where I come from, we talk about separate legal personality. In Australia, they typically talk about a separate legal entity. And a company is separate. It is a separate entity, a separate being. In English, we talk about it having a legal personality. And when you incorporate a company, you create a person. And the reason why we think about it in England as being a person is the company can enter into contracts in its own right, and it can own assets in its own right. So when the company buys something, it's the company that owns it. When the company employs an employee, it's the company that is employing that employee, not the shareholders, not the directors. And it's quite important to understand that, because often, particularly where a company only has a single shareholder or only has a single director, people and founders think of the company and themselves as being effectively the same person. And they think of the company's money as being their money. But from a legal point of view, it is very separate. And it's quite important to keep it separate in terms of the company's assets being the company's assets, your own personal assets being your own personal assets, partly to avoid liability for you personally. And that's what the second legal concept is, which is the concept of limited liability. And I think you've had a prior session where you've talked about different legal forms. And the most common form of business in Australia is a proprietary limited company, or a PTY Ltd. And the real benefit of this legal form is it creates a separate company with separate legal personality or separate legal entity, but it creates limited liability for the shareholders and the directors, which means that you personally, as a shareholder or as a director, are not liable for the company's debts. And that's really important because sometimes companies aren't successful. Sometimes companies do fail. And it's important to be thinking about that. And I'm not saying that to scare you. I'm not saying that to put you off. Absolutely, you should not. It happens, and it's nothing to be ashamed of. And it's not a bad thing. It's just, it happens sometimes. And even some great companies that have had huge successes end up going the wrong way at the end. And some of the biggest car manufacturing brands in the world, some of the biggest airlines have technically gone bankrupt at times. But with a limited liability company, your own assets remain safe. So if you have a car, if you have a house, if you have an apartment, no one can get those because they are yours. They're not the company's. And the company's debts, the money the company owes to other people, it's the company that owes that and not you. And so that limited liability is quite important. It's quite important to work to preserve that. And there are scenarios where that limited liability doesn't apply. And sort of technical lawyers will talk about piercing the veil and lifting the corporate veil. It is very, very rare for shareholders to be made liable for anything the company has done. And it almost always involves effectively fraud on the part of the shareholder and the company being set up as a sham for a fraudulent piece. The circumstances where shareholders do, though, end up liable is where they personally guarantee the debts of the company. And if you are borrowing money as a company, if you go to the bank and ask for them to loan you money to set yourself up, you will often be asked to give a personal guarantee. And that makes the person signing it personally liable for that debt. And that is something that you just need to be aware of. It is pretty much unavoidable if you are borrowing money. I'm not saying don't do it, because if you need the money, you're going to need to borrow it from somewhere. And that's the way that is just a consequence of borrowing money from a bank. But it's something where, if you can, you want to protect yourself and your assets and keep the company's liabilities separate from your own. One thing that sort of comes from this sort of limited liability is that you end up often people putting in place different corporate structures. And I've just got a couple of slides here just showing some common structures. And most small businesses, you don't need multiple group companies. Just one company will be great and serve every purpose you can need until you become a big company. But we regularly see companies growing fast and putting in place corporate structures that are set to sort of future-proof them. And there's a couple of common structures. And typically all of these companies have at the top of them, they have a holding company. And the holding company's only job is to hold shares in the subsidiary companies. And one common structure is illustrated here, where you have an operating company, which sort of has employees, it has contracts with people and so on. And then you have separate assets in different subsidiaries. And I've got asset 1 and asset 2 there, but there could be asset 3, 4, 5, 6. And if you were setting up a chain of restaurants, as an example, you might have a separate company for each individual restaurant. And so the chain as a whole would have a holding company and an operating company that manage group activities, but each restaurant would be a separate legal entity. And that would mean that if one of the restaurants failed, if it was in a bad location, didn't get much footfall, wasn't able to be profitable, that company could fail, could go insolvent without impacting the rest of the group. Because there's that limited liability I was talking about, which ring fences liabilities in that group company. So if you are thinking about a business where there's going to be effectively a whole series of separate businesses under a similar brand, and that could be restaurants, it could be food carts, we see it with hotels, we see it with all kinds of different structures where there are just separate businesses to ring fence liability like that. Another common structure, particularly for technology businesses, is to have an operating company which does the employing and does the contracts with counterparties, customers, and so on. And you have a separate company, often called IP Co, or the IP company, which owns the IP, the intellectual property. And although the IP is created by employees of the operating company, that IP gets transferred straight over to the IP company. And again, the idea there is that if something goes wrong, the IP company is safe and the intellectual property is safe because it is separate from the operating company. And so if the company incurs debts, goes bust, or if they get sued for something they're doing, the intellectual property itself can often be saved. And you can start a new business using the same intellectual property. What I haven't shown here is the sort of group structures you get when people start moving internationally, where often you'll sort of have a subsidiary for operations in every single country where you operate. I'm working with an Australian startup at the moment that I think has 57 subsidiaries dotted around the world, doing different things in different jurisdictions. The The next thing I just wanted to talk about really with you was directors' duties. And I've got a couple of slides here about why, and these are quotes from case law, things that judges have said in the past about directors' duties. And the issue here is that you've got the shareholders, and the company belongs to the shareholders. It's their business that they own. And the shareholders and the directors can be different and can have different interests and different desires, and their interests aren't always aligned. And because the directors control what happens, the directors can do things which are not in the interest of shareholders. And so the law imposes duties on directors, and it's really there to protect shareholders, because it's the shareholders that own the business and the directors that are running it. And to give an example of a sort of a business that most of you will have heard of, Telstra. Telstra's got millions of shareholders. It's listed on the ASX, but it's got a board of 5 or 6 people. And it's those 5 or 6 people who are entrusted to control the business and make sure that it is run appropriately for the benefit of all shareholders. And again, just going back to my first slide back at the start of this, Telstra's directors, they have a small number of people. Telstra has a lot of employees. There are a lot of people doing a lot of work for Telstra, from the CEO, the CFO, the rest of the C-suite, all the way down. And it's the employees that are doing a lot of the hard work and the driving value for shareholders. But the directors provide a level of oversight and control to protect the interests of shareholders. And here's the second quote about directors' duties, again, just taken from case law. And it's just a recognition that the interests of directors may diverge from those of shareholders. And in sort of the big end of town, when you're talking about Telstra's and the likes, there's a lot of the directors are very professional. There's a lot of shareholders. A lot of those shareholders have tiny percentage shareholdings. But it's really important to think about this in smaller businesses and businesses where there may be one person who controls the business, who is the main employee, who is the main director and the main shareholder. If there are other shareholders around, you as a director have to look out for their interests. I'm just going to skip over this slide very quickly, but the key thing when you get sent these slides is that directors' duties don't only apply to directors. There are other people who can be liable and can have duties as a director. Under Australian law, directors' duties come from 2 main areas. So I just had a question for Rajiv. Can directors own a share of the company? Yes, they can. Directors can own shares in the company. They're not required to typically. In some companies they are, but typically they're not. But when someone is a director and also owns shares in the company, you've got to think of them as having 2 separate hats and being 2 separate people. I'm just taking myself as an example, there'll be Simon, the director, and Simon, the shareholder. And although I'm the same person, I have different roles and different responsibilities in those 2 different capacities. But yes, Rajiv, directors can own shares in the company. Directors' duties come from 2 different areas. They come from common law, which is what we call judge-made law. So it's law that's developed over the years when cases have gone before judges and judges have made decisions about the law. And it also comes from statute. And the main statute that's relevant here is the Corporations Act, 2001. And there's a lot of overlap between the 2 sets of directors' duties. Again, I'm not going to run through all of these. We don't have time to do that today. But the main one I just want to highlight here is this one under Section 181 of the Corporations Act, the second bullet point, which is the duty to act in good faith in the best interest of the corporation and for a proper purpose. I'm really just going to focus on the first half of that, to act in good faith in the best interest of the corporation. So as a director, your responsibility is to act in good faith, so honestly, in the way you think is right, in the best interest of the corporation. And what the best interest of the corporation means is essentially the best interest of all shareholders. Not some shareholders, it's the shareholders as a whole you need to be looking out for. And you've got to be doing what you as a director think is right for them, and what you as a director think is the best thing for them as a whole. And the courts do recognize that different people can have differences of opinion. But if you do what you think is right, if you do what you think is in the best interest of shareholders, you'll generally be okay. And I think, just going back to something I talked about at the start about the company's assets being separate from your own assets. If you're a director, you've got to recognize that those assets are effectively the shareholders' assets. They're not yours. And you need to look after them and preserve them for the benefit of shareholders as a whole, rather than for yourself. And I say that there's a lot of people fail to see the difference between themselves and their company. And that shows up in lots of different ways, but it's really important to think of the two as separate. And it's just something I really wanted to emphasize in this talk. Directors do have duties under various other bits of legislation. So workplace health and safety laws impose certain obligations on directors. Environmental protection laws do, the Competition and Consumer Act and Australian consumer law does, tax law and so on. You, as you sort of progress in your business, you're going to come across the laws, you're going to learn laws, you'll be told about them by lawyers you deal with, by accountants, you'll find out about them on the internet. I think one thing that will set you in good stead in the early days is just to do what you think is the right thing, because generally the law doesn't punish people who are doing the right thing. And if you're acting honestly, you're acting in a way that is fair to people, people are going to, you're going to be in a better position than if you're not doing that. The last topic I wanted to talk about was shareholders agreements. A shareholder agreement is really there as an agreement as to how the company will be operated, and an agreement between shareholders about how the company will be run. And it's often useful to have that sort of agreement up front, because when shareholders start working together on a business, often they're friends or they're family, or they know each other well and they trust each other. But things can change over time, particularly as companies become successful. So there's a story I often tell about a friend of mine, Satvinder. And Sat had a business, and he had a business partner called Frank, and they built a very successful company worth literally hundreds of millions of dollars. They were best friends at university. They went into business together after university and built this phenomenally successful business. They fell out over a girl, and it literally was over a girl. And they just couldn't speak to each other anymore. And they had huge arguments, and they never had a shareholders agreement in place. They never had anything to say how the company should be run. And they both owned half of the company. And the company it almost fell apart because of the two of them not being able to work together anymore. And so, and the other purpose of a shareholders agreement is to protect the interests of minority shareholders. Often we see companies where there's one person owns 70 or 80% of the business, and then some smaller shareholders who own sort of 5% each or something. And those 5% shareholders don't have the level of control. They don't have the level of oversight of the business. And so they have put in place a shareholders agreement, which sets out a contractual framework that's supposed to protect them. The second bullet point there is just saying that anytime there are more than two shareholders, or two or more shareholders really, you should be thinking about putting a shareholders agreement in place. You obviously don't need it if there's just one shareholder, because you don't need an agreement with yourself. You can probably avoid it if there are two shareholders and the second shareholder is your spouse or your partner, or a very close family member that you trust implicitly. But if you've got outside shareholders, whether that's a co-founder, no matter how much you trust them, you know them, you should be thinking about putting a shareholders agreement in place, just to protect both of your interests, or all of your interests if there are more. This slide just lists some of the main topics that are dealt with in a shareholders agreement. And the first one there is governance, which is about decision-making and running the business. And really the key things are about how directors are appointed and removed. Under the Corporations Act, anyone who has more than 50% of the company can appoint a director or remove a director at any time. So going back to the example of a company which has one shareholder who owns 70% of the shares, in that scenario, that person could change the board at any time, however they liked. Often minority shareholders will want to have someone on the board who represents them and looks out for their interests. The other aspect of governance that's quite important is how important decisions are made. And so often you'll see in the shareholders agreement an acknowledgement that the business is going to be run by management, by the directors and employees, just generally, but some important decisions have to be approved in a special way, whether that's sort of a unanimous decision of the board or the board including a key director or a decision of shareholders who hold 75% of the shares. There are lots of different ways of structuring it, different ways of setting it up, but making it so that some decisions can't be made unilaterally. And one example of a decision that you wouldn't necessarily want to be made if you were a minority shareholder is the decision to issue more shares. Because you might own 5% now, but if someone issues 1 million of new shares, you suddenly own very little of the company. Another aspect of governance that is quite important is information rights. As a shareholder, you don't actually have much right to receive any information from the company. But often in a shareholders agreement, it will set out what you're entitled to receive. Do you get accounts on a quarterly basis? Do you get, can you ask for information you want about the company you own shares in? The next set of aspects that are sort of often included in the shareholders agreement are about shares and how shares are dealt with. What happens when the company wants to issue new shares? We've got a reference there to preemptive rights. Preemptive rights are a right for existing shareholders to take up shares when new shares are issued and to buy those shares before they're offered to other people. And there's then about share transfers. How can someone transfer shares? What do they have to offer the shares to existing shareholders first, or can they just transfer them and sell them to anyone they like? Drag along and tag along rights are also important. And a drag along allows a majority of shareholders, often a significant majority, 80% or so, to force a minority to sell the business, sell their shares. And normally you can't force someone to sell their shares, but if you've got a drag along clause, it allows the majority, whatever that's set at, to decide to sell the business and require the minority shareholders to go along with that. Tag along is sort of the opposite, which is where if someone is selling a lot of shares, a minority shareholder can say, I want to be part of this sale as well. And that's to protect the minority. Leaver provisions are also really important, particularly where there are two or more founders who both own shares. And these are to govern a scenario where someone ceases to be an employee or ceases to be involved in the business. Because you could have a scenario where you go into business with someone else. I go into business with Warwick, who will be speaking to you shortly. And we both intend to do the business together. We intend to work together. We set the company up so it's owned 50-50. And sort of a short while after the business is up and running, I decide I don't want to do it anymore. And I leave. I still own 50% of the business. And Warwick is now working hard on that business. And I get the benefit of all of his hard work. And Warwick might not think that's fair. And you might not think that's fair. But it's a scenario that happens when you go into business with someone. You can't assume it's forever. And leaver provisions just put in place a framework to deal with that, to talk about what should happen. And commonly that would include me in the scenario where I'm a leaver, giving up some of my shares so that Warwick ends up owning more of the company. But there are lots of different ways of structuring that. I'm sort of already used up my time, so I'm going to pass over to Warwick. I'm more than happy to take questions from you in the group session at the end, or if you've got any other questions, you can probably get in touch with me on LinkedIn or by email. My email is simon.leslie@knlgates.com. Thank you for listening to me.
Okay, thanks everyone. Let me just share my presentation. Okay, I'm now assuming everyone can see my presentation.
Yes, we can.
Great. Well, hi, everyone. I'm going to speak to you today about intellectual property. Now, intellectual property is something that you can own, but it's not something that you can hold. So it's not something that's tangible, but it is still something that can have quite a lot of value. So I'm going to talk through different types of intellectual property. Some of them are quite unusual, and you'll probably never come across, but I'll just touch on those briefly. I'm going to talk about confidential information and trade secrets, which aren't really intellectual property, but they sort of fall within the same bucket. And then I'm going to talk about third-party intellectual property and what you should be doing to make sure you don't infringe the third party's rights. So the first type of intellectual property I'm going to talk about is copyright. Now, this is the one that is most common, and basically it is something that is written, or it's a work of authorship. So it could be a computer program, it could be a sound and video recording, it could be music, a book, all of those things that are actually written by an author. And what this actually protects against is against someone copying that actual work of authorship. So photocopying the book, copying a CD, all of those things are protected by copyright. Now, this protection is automatic, so you don't need to register it in Australia. In some other jurisdictions you do. But basically, as soon as you have that right, that work of authorship, it is protected. And if someone copies it and they've copied your work, then you can sue them for breach of copyright. Now, the important thing is it doesn't protect any idea behind the work. So as an example, if you have a recipe that's been written down, that's protected by copyright, but that doesn't prevent someone from making that recipe in their restaurant and selling that food. So the next one I wanted to talk about is patents. Now, patents are sort of the opposite almost of copyright because they're not protecting the embodiment of what it is. They're protecting the idea. So it's protecting an invention. So it could be something like a device, a method, a process. And the idea behind it is that it prevents other people from using that idea on the basis that you have developed it. So as opposed to something like copyright, it could be someone who actually completely independently comes up with the same idea and tries to make something. If you have the patent for that, you can prevent them from doing that. So if you have an invention that's particularly novel and you think is going to have particular value in future, then that's when you should be thinking about patentability. Now, there's a few things about patents. First of all, if it is something that you think you're going to be patenting in the future, you should make sure that you maintain the confidentiality of that. It's very difficult to patent something where you haven't maintained the confidentiality. So there'll be some other scenarios where it's great to talk to everyone about what your business idea is. But when you're talking about something that is a unique, novel idea that it could be patented, that is not something you want to be discussing with others unless they're subject to a confidentiality agreement. Now, when you register a patent, that would only be, if you're in Australia, you would obviously go for an Australian patent first. Now, that only provides you with protection in Australia. So if you are thinking this is an idea that you want to roll out internationally, then you might want to be thinking about a patent strategy as part of your business plan. So Europe's a great one because you can patent it in all of Europe by just doing one application, but it's really the only place that you can do that. But then, other jurisdictions you might want to look at might be US or Canada or wherever else, but each one of those is a separate patent fee. Trademarks. Now, trademarks might be one of the first things that you come across in your business. This is your typical brand name. So this is your Nike, your Coca-Cola, your Puma, brands like that. It's not a business name, so it's not a restaurant name or something like that. It's basically a brand that is attached to a particular type of good, and it has a brand value when it is attached to those goods. For example, Nike doesn't mean anything if it's attached to a car. No one wants to go and buy a Nike car. So when you have a trademark registered, it gets registered in a certain number of categories. So you have the trademark registered against the category of goods to which you are applying that mark. And then that protects you from other people applying the same brand or the same mark to those same category of goods. But again, no one's going to stop you from making a Nike car. Now, you should be using the mark to have it registered. So it's always there is an assessment process that happens when you register a trademark. They will check to make sure that you are using that mark when you register it. So one thing that you might want to do if you are thinking that you do have this sort of business where you will be registering a trademark, before you start business, you might want to be doing a trademark search to ensure that there is no trademarks that are similar to what is the business name that you're going to be having, for two reasons. First of all, you don't want to infringe someone else's mark, because that can be expensive, because you might have to rebrand your business. And secondly, you might be wanting to get your own trademark. And if you want to get your own trademark, you're not going to be able to do it if someone else has a similar mark registered. So now these are the less common ones that you probably won't come across in your businesses. Designs, this is a product design, so it could be the shape of a chair or something like that. Circuit layouts, particularly only in the IT world, where circuit layouts can be protected. And the last one, which I didn't even know existed until a few years ago, plant breeders' rights. If you have if you're a horticulturalist and you develop a new type of plant that might be breeding between two different plants, then you can protect that so that no one else can grow that plant for a certain period of time. Okay, touching on confidentiality and trade secrets. Now, if you tell someone in business something, you tell them that it's confidential, then that is actually just automatically protected at law. The issue with that is that, first of all, evidence. Did you tell them that it was confidential at the time? Could they reasonably have known it was confidential at the time? Which is so for that reason, when we want to protect the confidentiality of something, we generally use an NDA, non-disclosure agreement, or we use or sometimes it's called a confidentiality agreement. Now, that doesn't have to be a big document. You can probably find one in various different places, but that can set out between two parties the exact categories of information that the parties consider to be confidential amongst themselves. And then you know that the other party is going to protect that information and it's going to be, the confidentiality is going to be maintained. The question then is of course, whether or not you want your information to be confidential. If you're just starting out in a business and you're trying to develop ideas, not something that's patentable, but if you're trying to develop ideas, sometimes it's great to talk to people about what your idea is, and they might give you some pointers and help you further develop that idea. If you're trying to get investors into your business, they're probably not going to want to sign an NDA. So, sometimes you really have to consider what the scenario is as to whether or not you want to be protecting the confidentiality of that at the start. Generally, if you've already got a business running and you're exchanging information with another business, then that's sort of when you might be thinking about entering into an NDA or a confidentiality agreement. I've mentioned patents. Confidentiality is key. If you want to patent something, make sure you maintain confidentiality of it. Now, data is an interesting one. And I've popped it in here because when you're talking about, there's actually no intellectual property rights in data. So if you have data that you see as confidential or as in need of protection, it's not covered by copyright, it's not covered by patents, it's not covered by anything else. You need to have a confidentiality agreement, an NDA, to protect that data if you're handing that data over to somebody. Third-party intellectual property. So we've talked so far about the intellectual property that you may be developing and what you may be doing to try and protect that intellectual property. But we also need to think about, are we infringing someone else's intellectual property? Now, we can't just copy a computer program and start using it in our own business unless we're properly licensed. Likewise, we can't copy recipes and sell them. We can make that recipe, but we can't copy it. So what you need to do is you need to make sure that you have an intellectual property license agreement in relation to anything that you're using. Now, as part of that license agreement, you also need to think about what happens if one or other party develops something new when that intellectual property is being used. Who would own that? Would that be the person who's licensed the intellectual property to you? Or would it be you because it's something new that you've developed? So then we sort of get into the discussion about that background intellectual property. So background intellectual property is something that was sort of already in existence at the time that the license agreement was entered into. And you might have some background intellectual property as well that you are bringing into that relationship. So it can get quite complex as when the two parties are coming together, both parties are bringing IP to the transaction, and both parties are trying to develop something together. But we just need to think about, just be cognizant of those risks and think about how we can handle those. And that was it for me on the basics of intellectual property. If nobody has any questions, I'm happy to take questions. But if not, I'm happy I think George is going to have a discussion about commercialization.
A quick question. This is Balu. Sorry, I couldn't be on the video. What's the typical cost of doing an IP on a product that you've done? I mean, what's the cost range to get it IP protected?
Yeah, so it depends on what you're talking about, because copyright, as I said, is automatic. So you don't have to do anything. You don't have to pay anyone anything. Trademarks, I mean, you can get us to do a trademark search for you, but you can also do trademark searches yourself on the IP Australia website. So if you're starting up a business and you are thinking of using a particular name that you might apply to a particular product, before you start that business, I'll be going to the IP Australia website and I'll be doing searches on those names to see whether or not it's already applied in the same category of goods that you wish to apply it. Now, if you're thinking about a patent, that really depends on what you are patenting. I mean, I'm not a patent attorney. It's a very specialized role. And if you're trying to patent a piece of technology, as an example, then there's a lot of work to write up that patent application. And just the legal work alone to do that would probably be, in the few $1,000s. And then you need to make the patent application. And that depends on how many jurisdictions you want to go in. I think the patent application fee in Australia is about $500. But then if you want to start going internationally, then it starts getting very expensive.
Thank you. But that doesn't stop others to copy that patent, right? For example, if you only register in Australia, somebody in Canada can go ahead and replicate that one.
They can, yeah. That's correct.
Yeah.
So, quite often what you can do is that you can register in Australia, and then there's certain countries where that protects you from registration of another patent for a period of time. So you can register in Australia, and then you will have, I think it's 2 years in order to register your other patent applications in other countries. If it's sort of a monetary thing, you get priority of registration in other countries.
Okay, should I get started?
Sorry, there's a question in the chat. Sanjeev is asking, what's the difference between a trademark TM and registered R? Is R better protection? Warwick, I'll leave you to answer that. You're the expert.
Yeah, I mean, they're not Australian terms. We don't use those in Australia. That is an American thing. Mm-hmm. And I think one of them is a trademark that has been an application has been made, so that's a trademark pending. Right. And then there's one where a trademark has been granted, so that's registered. But we don't use those in Australia.
Yeah.
Thank you.
Okay, thank you. Can everyone see my slides?
Yes, George, you should be able to share yours. Yeah.
Yes.
Good.
Are you able to see my slides?
We can see that.
Okay, great. Okay, today I will talk a little bit about IP commercialization. And first, thank you very much for Simon and Warwick, and already provide a very fun discussion about the business structure and also the basic concept of the intellectual property law. In my presentation, basically, I will cover a few issues. First, why IP commercialization is important, why we need to know intellectual property. And the second, what is intellectual property and how to obtain the intellectual property. And Warwick already well covered these two parts. So I will focus more on the commercialization of the intellectual property. Before we get started, and the first question is why we think intellectual property IP commercialization is important. If we get back to 30 or 40 years ago, when we talk about intellectual property, actually not too many people worry about that. The reason is because if you look at international trade, it's mainly dealing with tangible asset, the vehicle and other tangible asset. It's not dealing with intangible asset. But nowadays, and the intellectual property play a very important role. The reason is because intellectual capital now constitute more than 70% of the world wealth and resources. So it's also became very important part of international trade. So that's why intellectual property became very important. That's why we need to have a good understanding about IP commercialization and IP law and related. When we talk about the intellectual property, as Warwick mentioned, the intellectual property law is an umbrella concept. We don't, in Australia in particular, we don't have a specific law simply called IP law. Instead, we have a number of specific legislation dealing with intangible asset. For example, we have Patent Act, Copyright Act, Circuit Layout Act, Design Act, Trademark Act, and so forth. But having said that, in different countries, they have different intellectual property system. For example, in France and in Japan, they do have some code simply called intellectual property code. But again, they also have specific law like this. So the different countries have a different way to regulate intangible asset. Having said that, we also need to know, unlike other legislation, for example, competition law, and every country have their own competition law, they all look quite different. But when we talk about the intellectual property law, general concept about the patent, trademark, everything is very similar. The reason is we have World Intellectual Property Organization. It's a specialized agency under the United Nations framework. It's administrating more than 26 intellectual property related agreement. So we do have a number of international agreements dealing with intellectual property that will help us to harmonize the intellectual property law around the world. So if you look at the patent law in Australia, patent law in the United States, copyright law in US, and Australia, China, India, you may find they are different, but the main principle all same. For example, term of protection, the way the patent will be granted, recognized, is all very similar. Not only United Nations, the World Trade Organization, for example, also have TRIPS agreement, trade-related IP agreement. That agreement set up minimum requirement for all the WTO member and to regulate, to make regulation in relation to the intangible asset. In relation to the second step, obtain the intellectual property, and Warwick already provided a perfect summary. To say some intellectual property, we have to receive them through the registration. For example, trademark, patent, particularly patent. If we want to get a patent, we have to get it registered in the patent office. And domain name, if we want to get a domain name, we have to get it registered through registrar, domain name registrar. But on the other hand, some intellectual property, intangible asset, we don't need to get it from the registration. Again, trademark, why? Actually, just now, the last question one colleague asked, it may relate to this. in the United States, and indeed in Australia, we don't have very clear distinction between TM and R and circle R, but in the United States and also many other countries, when they use the circle R and trademark, that means that trademark has been registered. So R means registered. And when they use TM, normally it implies that trademark has been used, but hasn't been formally registered through the trademark office yet. So then we may come to a question, just like if we want to get our trademark protected, we need to get registered. But sometimes, and some business, they just start a business, they have some basic reputation, but they hasn't formally get the trademark registered. But it doesn't mean the mark they're using will not be protected. So long as that mark and already generate reputation has been recognized by the public, and it still can be protected. It's not through the trademark law, but through the passing off, the common law right, the passing off. If you have a reputation, if other people provide some misleading information and take advantage from you and cause you damage your reputation, and then you can sue them for passing off. And copyright, generally speaking, and copyright, and basically that's protect expression of the idea. It's not protect idea itself. Patent law protect idea. But generally speaking, and we don't need to get copyright registered. Having said that, let's look at different countries. For example, in the United States, and they also have a mechanism for people to get their copyright registered. Because if you get your copyright registered, and that can be relatively easy for you to justify your ownership and commercialize your copyright work. So when we dealing with copyright protection, yes, and we don't need to get copyright registered in order to get the copyright. But when we talk about commercialization, sometimes get it registered also can be one of good business strategy. Trade secret, and as Warwick and properly introduced, that doesn't require a registration, but confidentiality is very important. And what is step 3? What is IP commercialization? And first, we need to know. In the law school, and normally we introduce just like focus on what is intellectual property right, how to get them registered, how to get them protected. But when we call the IP commercialization, it's from different angle. For example, all colleagues here, and we are your future entrepreneur. As entrepreneur, and when we're dealing with the commercialization of IP, the angle can be different. So instead of focus on how to protect, how to register it, that can be the job we can pass to the law firm. And we may focus a little bit more, should focus a bit more on just like how can we convert idea or invention idea and into revenue, a marketable product. And then we think about what is the role the intellectual property can play in such a process. We got idea, but eventually we want this idea become a marketable product, so get revenue from that. And then we link back to the IP law we just mentioned. What is the role of intellectual property can play in such kind of process? Let's start with a classic example, and where we just mentioned, for example, the secret formula of Coca-Cola. So that's a very classical one. And this one, Coca-Cola, we can see big brand and make lots of money through the recipe secret formula. But then the question is, would Coca-Cola or other similar company like Coca-Cola, they will apply for a patent for the recipe? The answer is not. Why? Very simple, and because that will be protected by trade secret. Because if we get it registered as patent, and the patentability is, inventive type of various, that's a different story. And but even we successfully get registered as a patent, the term of protection for patent is 20 years only. So that means after 20 years, and everyone can make Coke. So that definitely is not what Coca-Cola wants. If they have the recipe, they can want to use it forever. So how can we do that? Trade secret. So long as this recipe is not public available. It's still confidential information, and it can be protected by the trade secret. So that's just one example about how can we convert idea and into the marketable product, and how the different type of intellectual property may help us to achieve this. Another thing I also want to mention a little bit more direct, it's like how can we make money, revenue, and from intellectual property? There's a different way. It depends on business model. For example, the use intellectual property in provision the service for reward to the third party. Just now, for example, IP licensing agreement is a typical example. For example, I already got a patent registered, but I'm a student. I want to continue with my study. So I don't have time to do the business. So what I can do? So if some company or investor, they found our patent, our technology is very valuable, marketable, they can say, how about they grant me a license? I will pay you the licensing fee. I will commercialize your product, software, and get revenue and make money from that. So get a licensing fee is one way for us to make profits from the intellectual property, for example, patent. Another way actually is assignment. Assignment is more just like a transfer of intellectual property. For example, again, some IT student, they in year one, and they invent something and apply for the patent, registered. But again, they're not as brave as Bill Gates or Steve Jobs. They don't dare to quit from university, set up their own business. But Tesla or some other big company, they found this patent is marketable. So they may offer to this student, how about I spent $500,000 and you just simply transfer your patent to me. And in that case, it's not licensing fee, not licensing right anymore. The ownership of the patent will be transferred from the student to the company. So after that, and the company will become the new intellectual property patent holder. And even the student, the original inventor, they will not have the right to commercialize the invention and he created, because the ownership has been transferred and from the student and to the company. So that's another way to make money. And third one is we also call it the sell the intellectual property and to the third party assignment. And when we talk about the process for commercializing intellectual property and creation intellectual property, and the capital can involve in such kind of process in the different stage of the or venture capital can be involved in such kind of process at a different in different stage. For example, if it's very fundamental research, so generally speaking, the government and they willing to provide funds. For example, ARC, Australian Research Council research grant, they will provide some grant to support researcher, for example, university, to conduct some research for some research and development in certain new technology. And so in that case, the university and the government, they will have ownership on this intellectual property. In addition to this, many companies, for example, Google, every year, they also have some seed grant, seed capital. For example, some students they come out with some brilliant idea, some pilot. So the Google and other big companies, they may provide some small grant to them. Just say, prove that to me. And you got some good idea. I think it's marketable. It's very possible. And they may grant us some seed capital and to apply our technology. And for example, just like at university level or at city level, and see whether it's marketable. And also be the capital and investment at startup capital. For example, we got a relatively mature idea and some venture capital, they want to make investment and to help us to expand or product and also distribution channel. And also we have an expansion capital. That may be doing the situation, for example, we already have a very good distribution channel, make very good money from our business, but we want to expand it. And in that case, we need more ground. For example, we already have a domain name acquisition in Australia, but now we want our product can be sold in the United States and other countries. So in that case, maybe we want to get more money, more investment, so we can commercialize and distribute our product to other countries. So in that case, maybe we need fund to make further investment. That's how the expansion capital can be involved. And the IPO is also can be part of that. But when we're doing this, that's basically just to highlight the different stage of the commercialization process. But it's always good to make a plan in advance. As Worky mentioned, when we make registration, for example, patent and trademark, we also need to pay attention. They all highly protected locally. For example, if I want to get a patent or trademark in Australia, I have to get them registered trademark registered in Australia, or in trademark registered in Australia also. But having said that, and the WTO, WIPO, World Intellectual Property Organization, they do have a mechanism, for example, through the PCT and the Patent Cooperation Treaty, and they provide us opportunity to get a patent and also trademark registered at the global level. But what are the differences? The difference is more just like that. For example, I only start business. I don't have very good revenue. It's not worthwhile for me to get my trademark registered in Australia, United States, India, Argentina, and so forth. But I can easily just launch one international application and name and nominate, for example, Argentina, Brazil, and India, and United States as a destination country. So it doesn't mean we naturally get the trademark registered in those countries. We still need to do it locally. But as start up, if we do it now, so basically we get the per date. So that means, for example, in 1 year time period, and there's different ways to calculate. Sometimes it can be 18 months to 30 months. Basically, other companies, they cannot register the same trademark in those countries anymore. But eventually, we still need to get trademark registered locally in those countries. So those just kind of a different strategy, and we can think about in advance. Instead of invest lots of money in the beginning and to get trademark registered in different jurisdictions, we can focus on Australia, but get them registered, one international trademark registered, and but nominate a number of countries that can be the potential market. But after 1 year, if we found, we only want to focus on US market, okay, that's fine. Get it registered in US. Maybe we just give up other markets. That's fine. And in addition to the IP law, and when we talk about commercialization here, and I also want to mention about the digital environment, because last week and when in session 6, when we got the IP expert to explain to our colleague to say how to set up a website, how to get domain name registered, how to commercialize or promote our business online. In the current digital environment, indeed, we do need to pay attention to how the existing law, traditional intellectual property law, or other even non-intellectual property law, and work in the new digital environment. Here, I just want to give you some example, and then maybe we will come across. One is, for example, the copyright ISP liability. The copyright and the history is very long, can trace back to Berne Convention several hundred years ago. But when we talk about the ISP, Internet Service Provider, we only have the Internet and in 1990. So the history is not that long. But the technology always can have significant impacts on our current legislation, including the copyright law. For example, in 2000, Australian passed legislation called Digital Agenda. Basically, they get Australian Copyright Act 1968 amended, include a special provision called it ISP Safe Harbor. So we don't have this law, and before we have internet, because the reason is if back to 1986, when the Australian have the first copyright law, we even don't know what is the internet. So definitely we don't need to worry about the ISP liability. But now ISP became very meaningful for us. For example, and even in our group, I know quite a few students, they want to set up website, provide IT service online. And also some students, they want to set up website selling the artistic work online. And in that case, if you have website, and in that case, you will operate as kind of internet service provider or internet content provider. So you have to deal with the situation. Sometimes, for example, your subscriber and your user, they may upload some copyrighted content to your website. Just like we can upload Facebook, we have Facebook page, we can upload photo to the Facebook. But how about if any user uploads some unauthorized copyright work to our platform on the Facebook? So for the user, subscriber, definitely they breach the copyright law. They are the copyright infringer. But here, under the new copyright law, they deal with situation just like, how about us? We as an ISP, we provide the platform. Our user upload unauthorized material. Do we need to take responsibility for that? And the ISP safe harbor legislation basically make it very clear. Once we receive a notice from copyright holder, for example, and the copyright holder told us one of our user and website user, they upload unauthorized material which infringe their copyright, and we need to take it down immediately. After that, we can enjoy full immunity. They cannot sue us for copyright infringement anymore. But the problem is, if we don't take it down immediately, and in that case, they still can sue the copyright user as a direct infringer. But on the other hand, they can sue us as secondary for vicarious liability. We still, they will say we authorize our user to infringe the copyright. And so that's how the technology may affect the existing law. That's something we do need to pay attention. But we also need to know a little bit of the technology part. For example, this law was Digital Agenda Act. It's mainly has been amended in 2004. It's mainly just to follow the free trade agreement between the United States and Australia. Because in that trade agreement, the US make it very clear, and Australia need to introduce US DMCA, Digital Copyright Act in the United States model to provide legal guarantee for the ISP liability. So that's how the international law harmonizes to each other. But having said that, we also can, if we know a little bit of technology and law, and we also can easily and to avoid such kind of legal liability. For example, now, when the US law was drafted and in 2000, and the ISP basically, and all the users, they upload their content to the web server. That's a central server. But now with the development of peer-to-peer technology, particularly now, cloud computing technology, what happened is when our subscriber upload unauthorized material to our website, we don't have control on those content. The reason is it's very possible. We simply pay the rental and using the platform and from the cloud service provider. Sometimes it's the cloud service provider in Australia, some can be cloud service provider in the United States. So in that case, when we receive a notice from a copyright holder, say, "Hi, please take it down, otherwise we sue you." But don't feel panic. The reason is we can simply reply, "We don't have control on this content, so we are not liable for that." So that's just an example, and the technology do have impacts on existing law, and we need to be aware of them and also make a proper response to that. So that's one example, just like in the digital environment, and we need to comply. When the company operate, we need to think about how we comply with the existing intellectual property law. But in the online process, commercialization process, we should also pay attention. IP law is not single concern. And we also need to think about the connection between the intellectual property commercialization process and other non-IP law. For example, Simon just provided a very excellent introduction about direct liability business structure. They are not intellectual property law. They deal with the corporate law, contract law. But the very important components and for the whole IP commercialization process, we need to decide whether what business structure we need to choose and which business structure and is the best for us. For example, and as you remember, Simon mentioned about it's always good if we have set up a separate company as an IP holder. So in that case, even one company failed, all intellectual property will keep untouched. So that can be one of the strategy to protect our intellectual property. It's also a very important strategy for the IP commercialization. So we can see the commercialization process is not only dealing with IP law, it's also dealing with many other legislation. And some other issue, like act, maybe can be relevant, and limited by time, we will not cover all of them, but I will give you some example. Some frequently used act, in addition to corporate act and the contract law, it can be the Australian Consumer Law, Spam Act, Competition Law, and Privacy Act. Warwick mentioned about the data, personal information is all covered by the Privacy Act. Sometimes also we have dealing with the taxation law. Here, let me give you some example about how the online business, the conduct of company, and may have some difficulty or compliance issue and with ACL or Spam Act. Let's look at this case, Merton. Merton Hotel, we all familiar with this. In 2017, there's a case between ACCC and Merton. It's for what? It's for breach of Section 18 of the Australian Consumer Law, misleading, deceived conduct. What happened is, when we choose a service, whatever Merton service or other hotel service, it's very easy. And for us nowadays, we just Google them and try to get look at review and feedback provided by the customer. And sometimes we also look at, for example, feedback on the TripAdvisor. But the problem is, and sometimes there's most of the TripAdvisor and also those online platforms, they will claim we are third party, independent third party, and we will provide very objective and observation. But what ACCC found in that case, it seems like there's some connection between Merton and TripAdvisor. And then, so basically, and in that case, Merton's management direct staff to encourage in the masking and stop and stopping potential negative review from appearing on the TripAdvisor. So then the ACCC believe this approach is misleading for the consumer. So then they sue them for breaching the ACL Section 18. Eventually, the penalty was $3 million. So that's one example. Lots of good way to promote our business, but we do need to make sure we do it properly. Second one is also classic one, the Wolf case in 2016. For the young generation, like play computer game, we're all familiar with this company, right? Steam. But sometimes we don't know is this company, we all know it's originally basically a US company. But sometimes we don't know maybe is this company don't have any premises in Australia. They don't have data center in Australia. They don't have employee in Australia. They even don't have any bank account in Australia. But ACCC in 2016 successfully sued them for breaching the Australian consumer law. One of the reasons for that, on one hand, because they have agreement with the data center in Australia. On the other hand, also most important one is this company, US-based company, they have more than 2 million subscribers in Australia. And after that, basically, the High Court eventually made a decision in favor of the ACCC. Say, also this company basically registered in the United States, but the Australian consumer law still apply. So also this case, basically, and the High Court made a decision in favor of ACCC. But when we're doing business, particularly when we're doing business at the international level, and we should also be prepared. And in addition to Australian law, sometimes some consumer law, for example, United States and other country may apply to us also, because U.S. Supreme Court, they may also hold, for example, if we use the cloud computing service platform to provide service to the people in the United States, it's very possible. And if we breach the consumer law over there, U.S. Supreme Court can do this something similar. Okay, let me wrap up. And the last one, and when we do the promotion, and last week, and one business strategy our IT expert introduced is through email, sending email and to the customer and which may interested in. But on the other hand, we should also know, and email has been highly regulated in Australia, particularly, and we have a Spam Act since 2003. And we also need to make sure when we do the marketing promotion, email promotion, and marketing, we also need to comply with the Spam Act. For example, we need to get permission from the person who will receive the email. And we also need to identify ourselves as a sender. We cannot hide our identity. And we also need to provide our contact information and also the button and which the user can click to unsubscribe and the email. So for example, that's an email I received today, and you can see that certainly is email marketing, right? But in this email, you can see they already identify who is the sender and also have the button and unsubscribe. So we can see this company, they do comply with the Spam Act, and they do the business in a proper way. And they do the promotion, but they also provide a user the way to unsubscribe such kind of email. So when we do the business, then certainly we also need to pay attention to all this. Lastly, and that's something it's very new, and we all know the Facebook and change the title. Now they move to the metaverse age, and in the digital environment, and lots of 3D image and have been created, and we enter a virtual world. But in the virtual world, actually, they also bring new challenge and for the IP law enforcement and commercialization. For example, now we got avatar in those virtual world. But how about if our avatar create something new in the virtual world, and who will have ownership on those artistic work or patent? It should be avatar, or should be ourselves or Facebook. So the technology keeping challenging the law, and also the bring lots of business opportunity for us. It's very exciting area to look at. Thank you. Yeah, happy to answer questions altogether.
Thank you, George. Before we maybe go out to the breakout rooms, just want to make sure, earlier I did mention about the profile of you guys, so we could put that on our socials to promote you. So we have 16 days now. So could you please kindly send out your profile ASAP? So we need half a page profile of yours. That we put on Facebook as well as LinkedIn. So that would be a great opportunity to talk about yourself. So just a nice and short one. And besides that, we have decided to run this event as a multicultural event. So everyone would get to wear the traditional outfit, whichever culture you come from. So, a great opportunity to highlight that. And besides that, we would also like to sing a couple of songs like I Am, We Are, I Am, You Are, We Are All Australian. So we are looking for some singers there. So if you know of someone, please connect us with them. We do need to finalize that ASAP. And we are also looking for some Indigenous singers to sing the Australian national anthem in their language. That's the first priority. But if in case that doesn't happen, we could just do Australian national anthem just the way it is. So yeah, that's it of the requirement from my side. Shall we still go to the breakout room, Sydney? What do you say?
Yeah, I think we can go into the breakout rooms. We can do the pitches. So in our groups, we can practice your 90-second pitch. We'll choose eight pitches to go into the pitch night. 2 Fridays from now. And also, we'll probably reconvene around 7:15, 7:20, just to do some closing remarks and seeing if there's anything else we need to do prior to the final session. So the final session is a pitch night. So really, this probably concludes the informational side, informative side of the program. So I hope you guys found it very, very useful. Also, please check out the forms that was sent out, surveys. They will be also used as part of the graduation ceremony. Let's jump into the breakout rooms.
So would you guys like to practice your pitches? We don't have so much time. Who would like to go first?
90 seconds, right?
90 seconds. So we could time it as well. Let me open the timer here. Who would like to go first?
Kumar, I was wondering, for the pitch night, are you allowed to have speech cards or not really? Just you need to memorize the speech, the 90 seconds speech yourself?
If you can't remember your 90-second, I mean, you could do a bit of a dot point. You should be able to do some dot points, but you got to remember it by heart.
Okay.
I would say.
And we're allowed the PowerPoint card. We're allowed PowerPoint slides as well, right?
PowerPoint slides. I'm not sure about that. We could always ask the questions.
Okay.
We could always ask. Please write it down. Send us an email so we could consult them with that. All right. Any other questions? If there's no further question, let's go pitch. Who would like to go first?
I'll go first.
Great.
All right. Great, Rajiv. Okay. You ready?
Yeah.
1, 2, and 3, go.
Skin cancer is one of the most common form of cancer around the world. People all over the world make billions of search queries in Google for issues related to skin conditions from sun exposure. To address this problem of skin health concern, we have created the DermaView app. The DermaView is the future of skincare. It will be your personal dermatologist in your pocket, always there to give you advice and information on how to keep your skin healthy. DermaView is a revolutionary mobile app that detects any possible sign of cancer by analyzing photos of the user's skin taken with their phone. Upload pictures of your skin and get analyzed by our app, which will give you information on your skin health with a skin health meter. The app then gives recommendations based on the health meter it assigns to each photo. The product has been designed to make it easier and more affordable for people to get screened for skin cancer, which can be difficult to detect without professional help. Thank you.
Right. So that's 71 seconds. Good. Like that. All right. Who's next?
Yeah, I'll go.
All right. 1, 2, 3, go.
Warren Buffett once said that the more you learn, the more you earn. Hi, my name is Sam Lee, and I'm a social confidence coach. I help people with socializing difficulties to improve on the social skills and be able to connect with confidence with people they haven't met before at any time. Social skills is very important in all walks of life. Whether it is your business, whether you want to build trust with your counterparts, for example, partners, affiliates, clients, your 9-to-5 job where you want to build trust with your uplines, for example, managers and want to get promoted as well as from a social context point of view, where you want to build your social network. And as they all say, your network equals your net worth. It is very true. My niche market is people who are shy, introverted, nervous, and lack confidence when it comes to socializing with people. You can also say social skills is life skills. You need it in your everyday lives. People who normally fall into this category are people in the IT industry, accountants, lawyers, admin people, etc. Ideally, they are all people who work in the back-end office type of roles. I want to build an academy where I can help people improve on their people skills with ethical social skills. I believe that the world can be a safer place to live in. As we live in a digital age, there are many people who have social anxiety and depression. And my goal is to fix this 21st century digital age problem. And what I want is to get more customers, raise more capital for this business. And I'm also looking for investors to help me scale this business.
Keep going if you want.
No, I'm done.
Okay. All right. So it was exceeding 90 seconds. You just have to work on that.
How many seconds was that?
You were just exceeding, and that's when I told you. So it was 92 seconds when I stopped you.
Oh, okay.
Right.
So it has to be below 9 seconds. Right?
Yes, absolutely. Yeah. It has to be around 60 seconds, actually, because people don't have, the mental capacity so much to really, go on to listening to a fast-paced pitch. So I would say make it maybe 70 seconds or something.
Yeah.
Yeah, definitely less than 90 seconds. So that was good. Who's next? You? Yeah. All right, go.
Is my sound working? I'm still having.
Your sound is working. So 1, 2, 3, start.
Okay. My personal mission statement is to use the universal language of creativity to transcend limitations of thought, inspire, and create change. And I will do that through the Excellence Academy. The Excellence Academy is a carefully curated and collaborative online platform that connects professional women of color who provide content, courses, information, and inspiration to other women of color with the aim of transforming their creativity, passions, and practice into commercial viable enterprises or businesses. It's designed to empower the creative to have agency over their own language. And I came about this because, have you ever just been sick and tired of something? Well, I got sick and tired of the idea of a broke creative. And I found in my own personal creative journey, like it was really hard to get mentors and information. So that is a fundamental foundation that I used to guide the Excellence Academy. So it takes into account the years of practice, creative practice, your budget, time, learning styles, relatability, and access. And what we offer is free information, subscription, long and short courses. And for this, the income stream will be through the membership from the content creators, paid subscriptions, and the long and short course fees. So in a nutshell, as a result of doing courses and accessing information from the Excellence Academy, creative women of color will be equipped with knowledge, information, and inspiration that will transform their creativity, passion, and practice into commercially viable enterprises or businesses.
98 seconds. So that's good. The pitch had oomph to it. You just have to shorten that up. Take away, 20 seconds. All right, great. Thank you. Who's next?
I'm happy to go next.
All right, thanks. 1, 2, 3, start.
My name is Vipha, and I'm the founder of Together We Can. Our mission is to bring people of all ages, cultures, professions, and religions together on a global platform to promote harmony and social inclusion. Together We Can is an initiative which aims to reunite people across the globe to promote the United Nations Sustainable Development Goals. Many young people are working to achieve the UN SDGs and engaging in social work on an individual level. There is only so much that we can do alone, but together we can do a lot. Did you know that 2030 agenda is already falling behind? And there is a large need to push towards meeting the UN SDGs. We aim to connect individuals who are committed to making significant changes across the globe to increase awareness about contemporary global issues, as well as discuss potential solutions. One of the projects that we have launched is called Walk Towards Peace. And another project that we will soon be launching will be a TED-style talk for migrants and refugees.
Is that it?
That was all.
Okay, all right. That was 60 seconds. Your line was going in and out. So, okay, 1 minute. I'm just thinking. So, in the coming days or in the coming weeks too, you'll be practicing your pitch, making your pitch perfect, and probably send it out to us. We'll try to meet once again on Wednesday. And then we will listen to your pitch again And by that time, we would have practiced a bit, everyone. And we could go from there. Thanks, Fiba. All right, who wants to go next? Jeremias?
Hi, Kumar. Sorry, I don't have the pitch ready now. I need to contact you tomorrow.
You want to try at all?
Nah, it's okay for today. Sorry.
All right. Melissa?
Oh, I haven't practiced mine either. I'm sorry.
Oh, you could try it.
No problem. You got it.
You could try it.
You explain very well. Yeah.
Well, start is the issue, but like we are not actually doing it in real. And so, in 16 days, you'll have to do that in real. And actually, we do have to qualify people now. So we have to listen to the pitches. So, please do us a favor and just work on it. Because definitely in a week time, we do have to qualify who is coming for the pitch. So that is 7 days. And and in a week time, that'd be showtime. All right. So please go ahead. Try. It's just a social setting here.
Okay.
Shall we? Do I go 1, 2, 3?
Okay. Do I allowed to read, or should I just set as my heart?
Oh, so everyone was reading there, So a bit of reading, bit of using your mind,
Okay.
Are you ready?
Okay, I'm ready.
Okay, so 1, 2, 3, start.
Hello, everyone. My name is Melissa Cavero. I'm the founder and director of Latin American Migrants Australia, LAMA Incorporate. The purpose of the organization is to help international students and people who are overseas but would like to come to Australia to improve their English. This organization is focused to help people from Latin and Portuguese background with different English skills such as grammar, pronunciation, writing, reading, IELTS, PTE, and so on. The organization has already started operating since a couple of weeks ago. The classes already begin. In this moment, we are recruiting new volunteers. So far, it has been successful. Students are so happy with the classes. And so that's everything.
Okay. So that's less than 60 seconds. All right, good. So what you guys have to do is you have to remember everything by heart. What I think you could be allowed to do is to have, one little piece of note, with dot points. This is all you should need, as a cheat sheet. You can't read a whole sheet. You would not be allowed to. And you would fail instantly, A pitch is not like looking at a piece of paper reading thing. That does not qualify as a pitch. I mean, pitch is something that comes from your heart. Okay, so you got to be a passionate. Like if passion is not there, reading a piece of paper doesn't make you passionate. You've got to remember your pitch. So what are you going to do in 1 week time? You've got to bloody, just practice your pitch inside out. And you've got to be able to deliver that within 80 seconds. 90 is the deadline, So you got to practice that perfectly. And the opportunity that we are trying to create here is bringing in, venture capitalists, some great ones, and then after bringing in some government ministers as well, like skills minister and some other high-profile CEOs, this would be a great chance for you. And some media companies are also coming. So I have seen some of the people from media like Channel 10 and some other journalists also coming. So if they like it, they would publish that. This is a great opportunity for you to make a name. So, make us proud, make yourself proud. So definitely spend in as much time as possible to just nail it. Okay. Who would like to go next? Fiba had raised hand.
Okay, I've just got a question in terms of the timing. So ideally, how long should the pitch be? You just said, should it be around 80 seconds, 60 seconds?
90 is the, you don't want to end it right at 90. I mean, when it's 80, you could probably end it at the moment, you could go in and out. So you might end it at, 85 or maybe 90. But if you practice it for 80, then, like you might have a tiny bit of moment to play, you might exceed. Yeah.
Cool. Thank you.
No worries. You never practice a pitch for 90 seconds because you're going to be over, at that time. Yeah. All right. We don't have many people. So Balu.
Hello. Yeah.
Balu, can you?
Kumar, sorry. I haven't really got all that done. I did give a pitch, but that wasn't good enough. I think that's in the beginning, but I'm still working on it. So probably.
Do you want to try at all? Anything you got?
No, I'm just redoing everything. So I'm just making it as best. Not ready there yet. So I'll have to leave at this point.
Okay.
And I'll give it the next time.
Well, yeah, as I'm saying, like we do have to finalize this thing soon. So that's okay. I mean, 8 people are, Fishburners is allowing 8 people. So yeah, please let us know ASAP. So yourself and Jeremiah and any other person. So, I mean, yeah, no worries. Anyone else? I think I have asked everyone to do the pitch. Questions, anyone?
Sorry, just another question. What's the criteria like in terms of getting picked to be chosen to do the pitch on the pitch night?
I think first thing which I was mentioning is, it has to come from heart. Secondly is the business has to make sense, right? To be picked up by the venture capitalists. So the business has to have just the right chemistry there. That's the most important thing. And it has to be presentable. So once we have a solid proof that, like person is pitch perfect, then we could present that. I think it would be a good idea for us to have a recorded version of everyone. So we could present that to Fishburners and anyone else, like probably judges, anyone else who is involved in that. So we have, proof that, okay, this person has got this idea. They're very good at the pitch, and then they could decide. And our team could also decide, because not all of our team are present here, in all those strategies. So that's my idea.
Can you hear me now?
Yeah.
Is this better?
Yeah, go.
Okay. So I was just going to say, so in terms of getting selected, does Opportunities Australia put forward a certain number of people to Fishburners and then they select, or is it the other way around?
It would be both parties, actually, because Fishburners has got venture capitalists as well. So we have to make sure that all our candidates are excellent, and they are, so it would be a mix bunch, Fishburners, Opportunities Australia, both parties selects, and yeah.
Okay, cool. Thank you.
Kumar, what's the setting like? Will we be standing up, or will we be sitting down, and we're going to be given a microphone and things like that? What's the setting like?
You'll be given a microphone, and perhaps you will come in front of everyone. So just be prepared. There would be around 200 people
that you're pitching in terms of.
You would come in front of 200 people. You will have a microphone. You will have, you'll have your opportunity there.
What if you like, you feel nervous and stuff like in front of that much people?
You feel nervous. It's like last minute how people feel, I mean, it's your chance there.
Yeah.
I'm sure people feel nervous, but you'll get over your nerves. Just nice and relax. I mean, just think that you got nothing to lose, really. And that's the opportunity.
And also the nervous is sometimes is very normal, and not only for us, even for I did read some report. A professor is Nobel Prize winner, and he can perfectly speak and in front of just like 50 or 100 students. But one day, actually, he has been invited to give a talk in front of 500 students in very large theater. He is a Nobel Prize winner, but he cannot even say one word. because he's too nervous. So even for them, they feel nervous, and we got good reasons for nervous, right?
Everyone gets nervous. You just go with the flow. You might be shaky. I remember one of Julia Gillard's pitch, in that her pitch is really, ex-Prime Minister of Australia. Her pitch is very shaky, but, you keep on pushing yourself. I get nervous all the time. You just keep on pushing yourself. Your voice might be shaky. You may not be 100% composed, but that's better than no pitch, right? So you just have to keep on pushing yourself. And if you keep on practicing, then you'd be okay. If you are pitch perfect and you feel confident, you got a great product there, you got a great pitch, all lined up within 90 seconds, you'd be feeling good. You just have to be nice and relaxed, be chatting with us, and then we'll send you out there, and you'd be right.
Yeah. And also, speaking about the question and Phoebe asked in relation to some kind of marketing criteria, in addition to the link and CD already provide in relation to how to make preparation about the pitch, I think another way, and also maybe you may find it useful, is after we record this, we just don't think about actually we are the presenter. We just assume we are the venture capital. We are the investor. Just say, if I hear this speech, would I put my money to this person? And then think about, if I don't want to, and how can I make improvement? That's also one strategy to help us to refresh, rethink, and restructure our idea.
Yeah.
So out of the 200 people, what's the success rate? Like, who should be nominated, like to get invested in, like? Do you know like a figure or something like that?
I did not understand the question. Out of 200 guests there, who would be?
Like there's 200 guests. Like, is there like a maximum number of people they'll take in?
Roughly, yeah. We would have to maintain a bit of a COVIDness, distancing and all that. But I hope you guys are those who are coming up. I hope you guys be double vaccinated. We just have to, check back with, are you guys all, gotta make sure that you are double vaccinated and all. Yeah, good. Definitely make your certificate ready. And actually, if you could send it out to us, I'm just thinking we aren't going to, misuse it or anything. I think those guys who have double vaccination, perhaps send me a copy of that. And if Fishburners ask about that, we'll make sure that we send it out, consult them. Okay, yeah, we have seen that and it's all good. So, yeah. Who else is there? Who raised the hand? I can't see. Unassigned, Sanjeev. Okay, any other question?
I think Steve messaged just now asking us to go join the main group.
Okay, no worries. I'm closing the rooms. Any questions?
Yes, I have one, Kumar. So I'm working on Friday from 1:30 to 10 p.m., but I'm thinking to take a break or ask for to be 1 hour off. So that will be from 5:30 to 7:30 or so?
Yeah, so the event goes between, definitely you can come around that time, and the event goes from 5 to 8.
Okay, 5 to 8. Okay.
Yes,
perfect.
5 o'clock people start to come, and 5:30 is when the event begins. So if you are really on a tight deadline, you could probably enter at 5:30.
Okay.
But 5 o'clock would be a good time to come in and start networking with people. So you have to assess your,
I will be online, sorry.
Pitch. So if you have any PowerPoint slides or a presentation, feel free to include it. It makes it a little more visual appealing as well.
Yeah, Michael in his pitch has got kind of a really neat kind of mini decker to support his pitch. So, and that's great because we were talking about how that would work in the session as well. So that's good to know.
Yeah, brilliant. Thanks everyone. Hope you had a great time practicing your pitches. We still have a bit of time to practice. The event is on the 26th, but I think we only have room for 8 pitches. So if you really want to do it, please let us know in the email. But I've heard some really great pitches tonight, so very impressed. Things to know next week. This was actually the final session for the 8-week program. Next week it is still in your calendars, so we might do a smaller version of this, maybe, just depending on interest. We don't have anything planned, so we could probably ruffle something together depending on what you are interested in hearing about. But again, if you want a break, that's also good. If you got enough information to work through, a lot of homework, then by all means go through that and refine your pitches.
Well, I just asked, are people allowed to do PowerPoints? Have you seen that, Sydney?
Yeah. If you want slides, a PowerPoint, feel free to prepare that. They do have that system.
Yeah, Wanika, we were talking about that in our breakout room as well, because Michael's got some slides that he's pitching with. So yeah. And it can sometimes be good to have kind of those visual kind of prompts for the audience as well.
Yeah.
Great. I can see Rajiv there. Hey, Rajiv, did you get your pitch through?
Yeah, I've got it.
Good.
Rajiv was good, yeah.
Yeah, it worked. But yeah, overall, sad to say that, the program is coming to an end soon. But it's been amazing to work with all of you. I know the mentors really found it, very positive to be helping you in your journey. I hope we did a great job to provide information and knowledge to help you on your business journey. But you did also well. So thank you so much for being a part of it. If you have friends that may be interested in the next one, let us know. We might run this again in the new year and hopefully make changes based on your feedback. But yeah, Michelle, George, Kumar, Simon, do you have anything you'd like to say?
Well, thank you to Simon and Warwick and George for tonight, and yourself, Sydney, and Michelle, and me too, to really help out, facilitate this. So yeah, I hope you liked it, Simon, Warwick, and George. Thank you very much. That was very useful. And I hope everyone else did enjoy that too. And we have a recording of that. So, it gets a bit difficult to, consume everything and, in just an ongoing setting. So you guys could go back to YouTube and, just pick their brains. And these guys are on LinkedIn and so you could always connect with them. So thank you. Simon and Warwick and George, would you like to say anything?
No, just best of luck to everyone with your businesses. Saw some great pictures tonight. Wish you all the best.
Those of you in Sydney, really looking forward to seeing you if you can make it in person on the 26th.
Yeah, absolutely. Very excited about that, and really excited to make it, a big multicultural event, or, as much as we could do.
Yeah. So yeah, it's going to be a great event. Hope you all can make it. Feel free to reach out to us on the emails if there's anything that you need help with. You'll probably get an email from us in the next week or so, just to finalize the guys that are going to pitch. And all the best. We wish you luck. Thanks again.
Please provide your bio ASAP so we could start talking about you. That's a good opportunity right now. So yeah, please do. Balu, go ahead.
On 26th November, it starts around 5:30 p.m. in CBD.
It starts at 5 o'clock actually. So 5 o'clock we meet for an event. So that was networking of half an hour, and the event kickstarts at 5:30 officially.
Okay.
So, yeah. And it concludes at 8 o'clock.
Oh, cool. Thank you.
The beer taps start at 5.
Sorry?
Beer
starts at 5. Exactly. That's the most important thing. The beer starts flowing at 5 o'clock.
Yeah. So, don't come too early, or you might not be able to get through your pitch.
Careful.
And everyone will be the singer after a few beers then.
Yeah, absolutely.
So we have to email you guys for in order to get to apply for the eight people. So I have to email you.
Just so that we know.
Drop us an email.
Yes.
Okay.
So we just pretty much just don't bring anything. Just come, dress up properly, and just come and just prepare and just present yourself and go for your pitch. That's it pretty much, right?
Yeah.
Okay, cool. So 5 to 8 p.m. Cool. Thank you.
Is there a dress code for the event?
Absolutely. An ethnic attire. Where have you been? Yeah, an ethnic attire. Wear your best ethnic attire.
Okay. Pretty confused about it.
All right, cool. Any further questions?
All right. In terms of the event details, Kumar was saying at the beginning, just in case any of you didn't catch it, there is it's an event on LinkedIn. You should also have it in your diaries from this group. But if any of you don't have it for whatever reason or can't find it, please just reach out and we can just make sure that you have it all.
If the event is on Facebook as well, please make sure to register on Facebook too. We would like that to look good as well and strong. There is a charge to it, $15 that they are charging. We'll try to see if they can waive it, but Fishburners is charging for the ticket. We aren't taking anything. So this is to provide food and drink for you. So we'll see if they can. Would that be okay by people, or we'll have to negotiate with Fishburners?
I'm sure because we're presenting, they might be lenient.
Yeah.
So we'll check first. And I know this is a lot of information to digest. We'll put it all in an email summary, and you guys will be ready by the 26th.
Yeah, we'll cross-check with Fishburners about everyone, so the participants shouldn't have to pay. All good. Thank you very much. Any further questions or comments?
I have a question. So I will connect online for the 26th. Should I connect by Zoom or just by Facebook? How can I connect and participate to the event? Because I'm in Melbourne.
Usually it's Zoom, but we'll confirm for you.
Yeah.
It will be the same link. Okay, you confirm.
It will be the same link because Fishburners we will provide you the link. So it's Fishburners that is hosting the thing. So they've got the IV, etc. So we'll confirm with them and we'll notify you as soon as we can.
Mm-hmm. Yep. Perfect. Thank you.
Awesome, guys. Thank you again.
Thank you very much.
Thank you. Have a good night. Bye, guys. Bye.